Are you a green card holder who travels outside the United States? Then listen carefully, because what I'm about to tell you could save your permanent residency status. The Department of Homeland Security has just announced new re-entry restrictions for 2026 that every green card holder must know about. One wrong move and you could lose everything you've worked so hard for. Thousands of green card holders are making critical mistakes right now without even realizing it. Stay with me till the end, because this information is absolutely critical for your future in America. Hello everyone, and welcome back to U.S. Immigration Insight. I'm your host, and today we're going to discuss something extremely important that affects every single green card holder in the United States. The Department of Homeland Security has released new immigration alerts and green card re-entry restrictions for 2026. And these changes could significantly impact your travel plans, your residency status, and even your future citizenship application. If you're a green card holder, or if someone in your family holds a green card, you cannot afford to miss this information. So, let's dive right in and break down exactly what these new rules mean and what you need to do to protect your status. First, let's understand why re-entry rules are so critical for green card holders. When you receive your permanent residence in the United States, you need to understand that your green card is not just a travel document. It's proof of your permanent residency in America. However, if you stay outside the United States for an extended period, immigration authorities may assume that you have abandoned your permanent residency. This is where things can get complicated and where these new 2026 restrictions come into play. According to the new DHS guidelines for 2026, if a green card holder stays outside the United States continuously for more than 6 months, they may face additional questioning and scrutiny when they try to re-enter. This rule existed before, but now it's being enforced much more strictly. Immigration officers at ports of entry are now requesting more documentation and verifying the reasons for your absence more thoroughly than ever before. They're not just casually asking questions anymore. They're conducting detailed interviews and examining every aspect of your travel history. If you stay outside the country for more than 1 year, the situation becomes even more serious. In this case, your green card can technically become invalid, and you will need what's called a re-entry permit. Under the new rules, if you return after being away for more than 1 year without a re-entry permit, the immigration officer at the port of entry can confiscate your green card and place you in removal proceedings. This means you could actually be deported and lose your permanent resident status permanently. This is not a hypothetical scenario. It's happening to people right now at airports across the country. Now, let's talk about what a re-entry permit is and how it works. A re-entry permit is a travel document issued to green card holders when they know they need to be outside the United States for up to 2 years. This permit remains valid for 2 years, and it proves that you have not abandoned your permanent residency. However, keep in mind that even this permit has its limitations. If you continuously stay abroad and keep using re-entry permits repeatedly, immigration authorities may become suspicious about your true intentions. They want to see that you have a genuine commitment to living in the United States. DHS has also clarified in 2026 that green card holders must maintain physical presence in the United States if they want to apply for citizenship in the future. For naturalization, you need to meet both continuous residence and physical presence requirements. According to the new guidelines, if your absences are too frequent and too long, your naturalization application can be denied, even if your green card is still valid. This is a critical point that many people overlook. They think as long as their green card is valid, everything is fine. But that's not true when it comes to citizenship. There are some important exceptions that you should be aware of. If you're working for the U.S. government or if you're posted abroad by a U.S.-based company, there are special provisions for you. Similarly, if you're outside the country due to humanitarian reasons or medical emergencies, you may be able to get relief by providing proper documentation. But in all these cases, you must maintain thorough documentation and proof of your circumstances. You can't just claim an exception. You need to prove it with solid evidence. In the new 2026 restrictions, DHS has also emphasized that green card holders must maintain their U.S. ties. This includes your U.S. address, bank accounts, property, family members, and employment. Whenever you re-enter the United States, immigration officers look at all these factors to determine whether your intent is to permanently reside in the United States or not. They're looking for evidence that America is truly your home. Do you have a lease or mortgage in your name? Are you paying utilities? Do you have children in U.S. schools? Are you employed by a U.S. company? All of these factors matter tremendously. If you know you need to be outside the country for an extended period, you should plan ahead. The application for a re-entry permit is made through Form I-131, and you must submit this application while you're physically present in the United States. The application process includes a biometric appointment, so you need to be physically present in the U.S. at the beginning of the process. You cannot apply for a re-entry permit from outside the country. This is a common misconception. People think they can apply from abroad, but that's simply not possible. Another important point that DHS has highlighted is the concept of continuous residence. If you stay outside the United States for more than 6 months at one time, it is automatically presumed that you have broken your continuous residence. This presumption can create problems in your naturalization application. You will need to rebut this presumption with strong evidence showing that your primary residence is still the United States. This could include lease agreements, utility bills, employment letters, and tax returns. The burden of proof is on you to show that you didn't abandon your residency. Taxation is also a critical factor that many people forget. Green card holders are considered U.S. tax residents regardless of where they physically live. If you stay abroad for a long time and don't file U.S. taxes, this can negatively impact your immigration status. There is information sharing between DHS and the IRS. So, maintaining tax compliance is absolutely essential. Failure to file taxes can be used as evidence that you've abandoned your residency. In fact, tax returns are one of the primary documents immigration officers look at when evaluating whether you've maintained your permanent residence. Let me share some practical tips to help you maintain your green card status. First, try to limit your trips outside the U.S. to less than 6 months. If you must be away longer, apply for a re-entry permit before you leave. Second, maintain strong ties to the United States, including keeping a U.S. address, maintaining bank accounts, and filing tax returns every year. Third, document everything. Keep records of why you're traveling, where you're staying, and when you plan to return. Fourth, if you're working abroad, get a letter from your employer explaining the temporary nature of your assignment. It's also important to understand what happens at the port of entry when you return. Immigration officers have the authority to question you about your absence. They may ask where you were, why you were gone, what you were doing, and when you decided to return. Be prepared to answer these questions honestly and have documentation ready. If an officer suspects you've abandoned your residency, they can refer you to secondary inspection, where you'll face more detailed questioning. Secondary inspection can last several hours and involves a much more thorough review of your status. Under the 2026 guidelines, DHS has also increased scrutiny on what they call long-term absent residents. These are green card holders who maintain their cards but spend most of their time outside the United States. Even if you return periodically, if the pattern shows you're primarily living abroad, you could face consequences. Immigration officers are now trained to look for these patterns and may challenge your residency even if each individual trip was less than 6 months. They're looking at the totality of your circumstances, not just individual trips. For those who are planning to apply for citizenship, these new restrictions are especially important. The naturalization process requires you to prove that you've been a person of good moral character and that you've maintained continuous residence and physical presence in the United States. Any extended absences can reset your residency clock and delay your citizenship application by years. Under the new guidelines, USCIS is being more strict about evaluating these requirements. They're denying applications that might have been approved in the past. Let me give you some real-world scenarios to help you understand how these rules apply. Imagine you're a green card holder who got a job opportunity in your home country for 1 year. You think it's fine because it's less than 2 years and you plan to come back. But here's the problem. If you leave without getting a re-entry permit first, when you try to return after a year, the immigration officer can deny you entry and take away your green card. Even if you have a re-entry permit, if you're spending most of your time abroad, you're creating a pattern that suggests you've abandoned your U.S. residence. Another scenario, let's say you're taking care of a sick parent in your home country. You keep traveling back and forth every few months. So no single trip is more than 6 months, but over the course of 2 years, you've only spent a total of 6 months in the United States. When you apply for citizenship, USCIS will look at your total physical presence and may determine that you don't meet the requirement. They may also question whether you truly intended to maintain permanent residence in the U.S. Here's another important aspect that many people don't realize. The definition of abandonment is not just about time spent outside the U.S. It's about your intention. If immigration officers determine that you intended to abandon your residence, they can revoke your green card even if you haven't been gone for a full year. How do they determine intention? They look at whether you maintained a home in the U.S., whether you filed U.S. taxes, whether you have family in the U.S., whether you have a job in the U.S., and whether you have other significant ties to the country. The new 2026 guidelines have also introduced enhanced technology and data sharing between different government agencies. This means that Customs and Border Protection, USCIS, and the IRS are sharing information more efficiently than ever before. If there's any inconsistency in your story or your documentation, they'll catch it. For example, if you told the immigration officer you were in Canada visiting family, but your tax returns show income from a job in India, that's going to raise red flags. Let's talk about the re-entry permit application process in more detail. When you file Form I-131, you'll need to provide detailed information about why you need to be outside the U.S., where you'll be staying, and when you plan to return. You'll also need to attend a biometric appointment where they'll take your fingerprints and photo. The processing time for a re-entry permit can be several months, so you need to apply well in advance of your planned departure. Once approved, the permit will be mailed to you either in the U.S. or at a U.S. embassy or consulate abroad, depending on what you requested. One common question people ask is whether they can extend their re-entry permit. The answer is no. A re-entry permit is valid for 2 years from the date of issuance and cannot be extended. If you need to stay abroad longer than 2 years, you'll need to return to the U.S. and apply for a new re-entry permit. However, if you're repeatedly applying for re-entry permits and spending very little time in the U.S. between applications, this will raise serious questions about whether you've truly maintained your permanent residence. It's also worth noting that having a re-entry permit doesn't guarantee that you'll be allowed back into the United States. It simply shows that you didn't intend to abandon your residence when you left. The immigration officer at the port of entry still has the authority to question you and examine whether you've actually maintained your permanent residence. They can still refer you to secondary inspection or even to an immigration judge if they have concerns. For green card holders who travel frequently for business, the new guidelines present particular challenges. If your job requires you to travel internationally on a regular basis, you need to be very careful about tracking your time outside the U.S. Keep detailed records of all your trips, including dates of departure and return, purpose of travel, and where you stayed. This documentation will be crucial if you ever face questions about your residence or if you apply for citizenship. The impact of these new restrictions extends beyond just maintaining your green card. If you have family members who are waiting for you to petition for them, extended absences can delay or jeopardize those petitions. If you're in removal proceedings for any reason, spending long periods outside the U.S. can complicate your case. If you're applying for any immigration benefits, your travel history will be scrutinized. Let me also address the situation for conditional permanent residents, those who have a 2-year green card, typically through marriage. The rules are even stricter for you. You need to file Form I-751 to remove conditions on your residence before your card expires. If you spend significant time outside the U.S. during this conditional period, it can raise questions about the legitimacy of your marriage and your intent to reside permanently in the U.S. USCIS may deny your petition to remove conditions if they believe you've abandoned your residence. Now, let's talk about what you should do if you're already outside the US and you realize you might have a problem. If you've been gone for more than 6 months but less than a year, and you don't have a re-entry permit, you should prepare extensive documentation before you return. Gather evidence of your US ties, your reasons for being abroad, and your intent to return. This might include proof that you maintained your home in the US, continued to pay bills, kept your job, or had family in the US. If you've been gone for more than a year without a re-entry permit, the situation is more serious. You may want to consult with an immigration attorney before attempting to return. In some cases, it might be better to apply for a returning resident visa at a U.S. embassy or consulate abroad. This is a special visa for lawful permanent residents who stayed outside the U.S. for more than 1 year. However, this application requires you to prove that your extended absence was due to circumstances beyond your control and that you didn't intend to abandon your residence. So, everyone, that was the complete and detailed information about the DHS Green Card re-entry restrictions for 2026. I hope this video has been helpful and you now have a clear understanding of what your responsibilities are as a green card holder and what precautions you need to take to protect your status. Remember, having a green card is a privilege, but it comes with significant responsibilities. If you know you need to be outside the US for an extended period, plan ahead. Apply for a re-entry permit before you leave and maintain strong ties to the United States throughout your absence. Don't take any chances with your permanent resident status because once you lose it, getting it back is extremely difficult and in many cases, impossible. Your green card represents years of effort, investment, and dreams for your future in America. Don't let a misunderstanding of the rules or a lack of planning jeopardize everything you've worked so hard to achieve. Stay informed, stay compliant, and always err on the side of caution when it comes to international travel. If you found this video helpful, please hit that like button, subscribe to US Immigration Insight, and turn on the notification bell so you never miss an important update. We're constantly monitoring changes in immigration policy, and we'll keep you informed of everything you need to know. If you have any questions about your specific situation, please leave them in the comment section below, and I'll do my best to answer them. However, for complex situations, I always recommend consulting with a qualified immigration attorney who can review your individual circumstances. Thank you for watching US Immigration Insight, and remember, stay informed, stay compliant, and protect your American dream. Your future in the United States depends on understanding and following these rules. Don't become another statistic of someone who lost their green card due to lack of knowledge. Share this video with any green card holders you know, because this information could save their status too. Until next time, take care and safe travels. See you in the next video from US Immigration Insight.